Here we go. Well, welcome everyone. We have quite a showing. Even before we started, I already saw 20 people signed in 20 minutes prior to. This is showing that there is a lot of interest in today's topic, which are the updates on Canada's Startup Visa program. The nature of today's seminar, meeting, however you want to call it, we're going to have Mr. Greenberg, Mr. Hamid, give us legal perspective. We're going to have them giving us a little bit more information from the trenches of battling the government when it comes to Startup Visa and handling hundreds of cases, both that are smoothly going through as well as those that have been rejected. So the goal is to see what can we do as the industry professionals to help success in the Startup Visa as the field. I'll share my screen right now, just a few updates, kind of what brought us to today, and then we'll have Howard and Aman proceed in giving their point of view as well. So let's start off with, and here's our kind of cover slide. From my perspective, we're going to have two different perspectives. We're going to have the legal perspective, consultant perspective. So right now, perspective from Slava Pell, which is my name, CEO of StartupVisa.Ca, also known as Startup Visa Services. So lots of changes have happened in 2024. I've been in the startup field or in a business ecosystem field, helping startups for over 20 years, and haven't seen so many changes coming so fast at us at once. So Ottawa has introduced two-year cap on international student visas. They change how occupational work permits work, how postgraduate work permits work, but that's not the topic of Startup Visa. I'm going to be speaking from the perspective of someone that has been working as an issuer of the letter of support on behalf of angel groups. I have been the person that actually issues the letter of support, fills out the letter of commitment. I have reviewed hundreds of cases and only select few ended up getting that letter of support. I'm also a mentor and advisor in multiple designated incubators. You can see some of the graduating students behind me as well. Every one of those has received their letter of support. I work in venture capital funds, in multiple angel groups and multiple incubators. So I have seen it from the side of reviewing businesses and issuing letter of support or reissuing letter of support and working with the entrepreneurs. So everything leading up to the point where immigration professionals will be filing for PR, for work permit, and that's something that Howard and Aman are going to be talking about. So how did we get to, and right now we are almost end of November, how did we get to where we are today? Well, in December 2023, government puts on their website, IRCC puts it that they're evaluating Startup Visa program. And I know that Howard and Aman were instrumental in advising government on that as well. In April, they did a full pause on application intake for self-employed persons program. They gave us a warning shot on about April the 12th that there are going to be new ministerial instructions regarding applications for Startup Visa, and they were paused on Canada Gazette. So people knew prior to April the 29th that changes were coming, and a big change came out on April the 29th with an announcement, which I'm going to show you in the next slide, that would take effect on April 30th. We literally had less than 24 hours to get ready for it. Big announcements that came out in the Startup Visa field, changing how designated organizations are processing the applicants and a few more rules. So on April the 29th, we had the big announcement. April the 30th, it has taken effect. May 7th and 8th, I attended the event by NACO in Ottawa, looking for some additional instructions, because at that point, NACO was the responsible body overseeing angel groups, overseeing incubators. We didn't get a lot more details there. May 9th to 11th, Canada Bar Associations, where our team we were present there, we were sponsors there. In Montreal, there was a summit. Again, legal professionals were discussing between themselves how to adjust to the new orders that have taken effect on April the 30th. May 16th, there was a NACO clarification call. So and this is what the NACO meeting actually ended up looking like. And what were the big changes? Well, on April the 30th, the biggest change to the Startup Visa program, where instead of unlimited letters of support each designated organization could issue, and the top five were issuing close to 300 per year. Now it has been reduced and cut down to just 10 each. Some designated organization truly went out of business based on that, because their entire programming, entire staffing, entire livelihood was based on helping entrepreneurs, training entrepreneurs, teaching them, charging them fees for that. But in the past, they were scaling up to be helping 100 businesses. Now they could only help 10 businesses in entire year. What did it mean? Right away post-announcement, when we look at angel groups themselves, they've gone from many to just a few, and you can see that directly on the Government of Canada website. So that was kind of the first blow. Second blow was very recent, and when I say very recent, just a couple of weeks ago, we've gone from previously announced plans for federal business immigration program of accepting 5,000 to 7,000 to 8,000 business-based applicants. They now cut it down just weeks ago to just 1,000 to 2,000. So even with having 10 approvals that designated organizations could be issuing, the total number of people permitted to be getting their permanent residency under Startup Visa and other business programs have been cut down to just 1,000 per year. And yet government has thousands, over 15,000, some people say 20, some 30,000 people in a backlog. So even this 1,000 to 2,000 are probably not going to be looked at for a very, very long time. Similar story has happened previously in UK. So Canada and UK have a very similar immigration program, where in UK from 60 designated organizations, when government has done similar changes, they have done just to 4. So where does it all take us? And this is where I am going to be passing the mic back to Naman and Howard, and they're going to take us through what they are seeing from the trenches. So over to you.
First of all, apologies for my camera not coming on, but that's probably a good thing for our audience. Naman, do you want to start the conversation?
Sure. Maybe, well, thank you very much for the background, Slava. That was a nice, in 3 minutes, you covered a lot of action. I would tell you from legal perspective, Howard and I have been deeply involved with the Startup Visa program from the very inception to where it is now. And the first thing that we would tell you is, you as a client, you have to stay tuned, because this is a little exceptional. Slava, you make the point that we got notice on April 29th of a monumental change that applied the next day. Right. And from that point of being notified, designated entities scrambled to try to first understand, what does it mean? They had a business to run. They had cases that they had to assess that were at different levels of completion. And since then, Howard and I think we bucket our practice in 2 areas. We have the clients that we work with from the beginning. So we've seen every aspect of their business, their thinking. We've hand-holded them. And we've got a level of comfort because we've advised them about what the program requires. And when changes occur, we work very closely with them. And then what we've seen is people coming to us since these changes, trying to make sense of whether they're okay. And we've seen a number of different issues that have been very complicated. After April 30th, we had individuals with certificates. Some were issued just before that date. Others had certificates in hand, but within the 6-month period, they weren't able to meet all the requirements. They couldn't necessarily get the language test done. And now we're in a new regime where you need, one of the identifiers in order to file the application. Much of this information, you point out correctly, Slava, there are ministerial instructions that comment on how to manage the inventory, but some of the guidance is actually on the website. It's on the website, but it's not referred to in the regulation, and it's not specifically described in detail. And so what we're finding, and Howard will talk to you a little bit about some of our interaction with the federal court, and there's lots of different perspectives there, and I think we do anticipate a lot of litigation, is that this is subject to a lot of interpretation, and it's very important in the interim to really identify issues beforehand and try to mitigate some of the problems. And today, we'll give you a list of some of the most common problems we've seen and how we're fixing them. But let me hand it over to Howard, and he'll give you some of his opening comments before we go deeper.
You must appreciate that the regulations were devised at a time when the thinking was that there would be a handful of applications. There wouldn't be a flurry of applications like there has been in the last 2 or 3 years. And a lot of time and effort has not been put to the detail of the regulations because, for obvious reasons, there wasn't enough flow to worry about. However, after the changes to other parts of the immigration program, particularly in the self-employed area, there was a flurry of activity, of movement of people over to the SUV program because it was the only real business option available. And what turned out to be a handful of applications probably would be now, what would you say, Naman, about 15 to 25,000?
We've got at least an inventory of 16,000 and climbing as new certificates are issued.
So the problem that you have is that a number of people had filed their applications under these regulations, and these regulations were really not designed to address the number of situations which have come up, anomalies that have come up. And so there was a time when you could correct these issues by simply issuing a new certificate, and these designated entities were quite willing to do so, to add an essential worker, to take out an essential worker, to change some of the terms of the business model that was initially anticipated. But with the changes which Slava has just described, each designated entity only has 10 certificates that they can issue, and therefore the problem arises. You can't easily change a certificate from one to another because the designated entities will not give up those precious certificates, at least not at the current cost of those certificates. And so that has caused a little bit of a crisis in the marketplace. And as an example, I just pleaded a case before the federal court, which was, I thought, very straightforward, meaning a designated entity had provided the certificate and the permanent resident application was filed together with the certificate. And so that met the requirements of the regulations, which were fairly basic. And sometime into the application, the applicant decided to exchange one designated entity for another. So one certificate was withdrawn, and the second certificate was put in place days later. And to my surprise, the court held that in the absence of the first certificate being present, the application would be refused because a strict reading of the regulation required that it be that certificate at the time that the application for permanent residence was filed. And so that's opened up a whole Pandora's box for Noman and I and our colleagues. That was a situation in which a certificate was vacated and another one was replaced days later. What if you just want to change the current certificate? What if you just want to, you don't want to vacate it, but you want to alter its terms? Do you have any thoughts on that, Noman?
Yeah, that's probably the biggest issue when we were observing the case. A couple of observations. Firstly, the judge interpreted the situation, and the Department of Justice also agreed and went as far as to say, we agree this is unfair. And in fact, one of them said, if I was the officer, I would have actually continued processing. However, you can't say that the officer was incorrect in reading that provision narrowly. And so as I was listening to this and seeing the decision, I was curious in all of the other circumstances where we've been dealing with businesses. In many cases, the certificate has fundamentally, there have been changes. In the past, we've seen that certificates have been updated. We've also seen circumstances where the activities of the business after 3 years or 4 years of being in Canada, it's very reasonable that the circumstances around a startup will change. But could we find that the material differences between the certificate that was issued and the activities that have occurred are significant enough that they might view that to be a deviation? That because we can't update the certificate as easily, and we know the website now states once one PR application is filed, the website, which is our authority here, not the regulation, but the website says that you can no longer update the certificate. Now, Slava just explained the immigration plan and what the backlog is like. And we're going to talk momentarily that immigration's introduced a 3-year open work permit, which means they're already contemplating that many of these businesses will be here at least 3 years. There is not a lot of provision right now to be able to connect the reality of what happens in the ground and the terms of a certificate. And the federal court has made it very clear that an officer can take a very narrow view of that certificate. And so I think that's probably the area where when you're submitting your application and when you're working with your designated entity, you have to be as broad as possible in terms of understanding the possibilities of the business and forecasting the circumstances. And anytime there's a pivot in your business, you have to try to tie it back to the principles that were supportive in issuing the certificate. So I think it's become, Howard, a lot more complicated than in the past, where when we saw what we thought was a material change, it was more about communicating with the designated entity, making sure they're aware if they needed to do another light due diligence, completing it, and then updating the certificate. So when the officer looked at the application, everything lined up. Now you're going to have a 3 to 4 year gap between the certificate and what has happened. And I think that's going to be probably the biggest challenge in this situation that we see now.
We might bring Slava into this discussion. Now that we know that the regulations can be read very strictly and that there wouldn't be that discretion that we would have thought from a common sense point of view could be applied, then we now know that those initial certificates, the contents of them, are critical, and that we have very little latitude in terms of changing those certificates. We'd have to replace it with a new one, and there's reluctance by the entities to give up one of their 10 precious certificates. The report that's done by advisors like Slava that gets incorporated into the certificate is critical, because there has to be now foresight as to what could change. And that has to be contemplated in the business report. And there has to be that flexibility that the certificate can contemplate various changes in the involvement of the individuals, their particular roles and responsibilities. Slava, you want to talk about that from your point of view when you put together a business report?
On a designated organization side, or on the business consulting side, so we are the ones that are helping candidates to put the proposal proper, the way that it would withstand the scrutiny in the past from potential peer review, which is no longer available, and nowadays to IRCC scrutiny. We have a few tools under our belt to help out, such as if there are multiple founders, 1, 2, 3, 4, 5 is the maximum. If some of the partners feel that not everyone is serious about coming to Canada, they may or may not stay in their country of origin, they may or may not pass through all of their medical tests, through all of their criminality tests. So they can signal to a designated organization that that is an issue. And in that case, designated organization may mark that person as a non-essential individual to that business, meaning they get treated the same way they also get to enjoy the application for the permanent residency. But if their permanent residency is denied for any reason, the rest of the team would survive and go on. So meaning 3 out of 5 could be marked as essential, 2 out of 5 as non-essential, and those that are non-essential to the business, even though they are in the same application, if they are rejected, the other 3 will survive. So that's one of the things that we can foresee in advance when we are crafting that letter of commitment and the letter of support. Another thing, and as you said, we do write all of the reasons why someone should be coming here sooner on a work permit, what their activities are expected to be, what they're going to be doing, and yes, potential pivots and changes in the company, who potential competitors are, and the whole thing about Startup Visa is to ensure that that's an innovative business, and because of that, there shouldn't be direct competition to that. But all of those things get marked in their letters of commitment. They are not seen in letters of support. Letter of commitment is a much bigger document. It outlines a lot more. And on your side, Naman and Howard, you would also be filling some of that information in a Form 13 as well. But we do try to preempt any type of question that IRCC may be going back and asking those individuals. We also provide them with training. What is the minimum activity that they should be putting in to make sure there is no red flags that the business is dormant or abandoned? So on our side, we prepare the candidates. What are the things that IRCC is looking for, what they should be doing, and how to mitigate any potential changes. We have had, now I've been working in this field for a long time. We have had people, while they're waiting, getting married. So meaning now we're going from 4 people, each one of them receiving letter of support. Now they need to be just 3. So we had to reissue. We have had people die throughout the process. So we had a case where someone just could not be found. There were 4 members in a group and one was just absolutely absent. His relatives could not find him. A legal representation could not find him. So we just assumed that the person just died and didn't tell anyone about that, of course. So we had to go out in the past and make those changes. Today, those changes would be absolutely detrimental because designated organizations, they have just a handful, just 10 of these numbers that they can put on a letter of commitment / letter of support. So for them to reissue one, it would be giving up one of those 10 seats. And they are very much reluctant to be doing so. What we've also seen, IRCC has been getting back to designated organizations and asking, are you still supporting this applicant? Because letter of support has only 6 months validity. There is an expiration date to it. So they would call up the designated organization, say, a year later or 2 later, and they'll ask, are you still supporting it? Meaning, we're not asking you to reissue it again, the letter of support / letter of commitment, to which, of course, every designated organization will say, yes, we're still supporting it. But also we have seen in the past where IRCC would get back to the designated organization and to the applicant and say, reissue the letter of support because it expired. So you have some IRCC agents understanding what they are doing, meaning, hey, are you still supporting it? In other ones, this is expired. It has only 6 months validity. Yes, I'm reviewing this only 1.5 to 2 years later. Where's my updated one? So that's going to be another interesting turn of events where no designated organization is going to update it and issue a new one just because the old one has expired.
Well, this presents some interesting issues, which will be over to our side, Naman and myself. We lately have been seeing many of these applicants, group founders, coming to us saying there's changes in our organization. The approach that we take is as follows. The first thing we do is look at the regulations, including the ministerial instructions. What do they say about what we can do in terms of changing anything in the application process that we've already done? Then the second step is to look at all the policy announcements by the department that they have put out. And they put out numerous operational instructions to see what guidance there is in the instructions. And so on the first step, we don't see the regulations addressing the issue of changing a certificate at all. And it was not contemplated at the time that the regulations were promulgated. So the next step is take a look at the policy statements, the policy pronouncements. What do they say? And more recently, they have published a policy pronouncement which suggests that the applicants are locked in with their certificate the moment that an application for PR is filed by one of the founders. At that point, their view is nothing can be changed. Our view is that that has not been addressed by the regulation, and a policy pronouncement is not a regulation, and we believe this is one of the major issues which is now going to be considered in the courts within the next 6 months to a year. To what extent can you change a certificate, alter a certificate, keep the existing certificate, but change some of the contents? Because over time, things change. Business proposals change, the economy changes, the business setup changes. It's not appropriate to hold an applicant to the strict terms of the initial business report and application in this kind of environment. And so we think that that is where we're going. And that leads us, Noman, if you want to comment on that, that'd be great. But then that would lead us into open work permit discussion, because there is a strategy here we could discuss.
Yeah, so maybe I'll just make a comment that in our experience in other areas, we've received procedural fairness letters where the officer very much focused on concerns that related to issues in a website, on the IRCC website, a particular bullet, but was not supported by the regulations specifically. There wasn't a ministerial instruction, and we challenged it head on to explain that here's the rationale as to what occurred with a full explanation, noting that this issue is not covered by the regulation. And we've had cases continue right till approval. So I think wherever they're governing outside of regulation by website, and website, sometimes you wake up and it's gone or it's added. So there's an essence of fairness here too, and we've been advocating very hard. So I think to Howard's point, that's definitely, we have a number of situations where we feel like there is a very reasonable course of business action taken, and the one comment on the website is not in line with the rest of the regulations. So we'll watch carefully on that. The open work permit's an interesting sort of pivot. We know that Minister Fraser, right, in the summer 2023, was celebrating back when the doors to Canada were wide open, that we would see an open work permit. And that was more premised on the fact that at that time, we just needed innovative, smart people coming in, and we needed volumes of workers. And that was the premise in which it was introduced. And then obviously with Minister Miller looking at the housing crisis and a lot of the political hotbed that immigration became privy to, pulled back significantly on many of the policies, really tightening down. So we didn't think we were going to see it. We didn't. We just thought that went outside of the focus because of the climate. And then we saw very recently, again, the introduction of the open work permit, which surprised us at first because we thought, what are you doing? I mean, first of all, you're talking about restricting work permits. Now you're giving a 3-year open work permit, which is very challenging in today's climate to get in any program. And in classic IRCC fashion, it came out in 3 different increments on the website with different instructions every few days, from a very convoluted, complex process that really defeated the intention, where you had to wait for an AOR, which would mean waiting 15 months before you could apply if it was a new application, some instructions that were fairly confusing. And then finally, they streamlined it to say, you know, effective now, you can, as long as you've filed proof that all your members in the team have filed an application for PR and you have proof of filing, you can request a 3-year open work permit. And we think the context here is more so a duty of fairness to applicants, that applicants will be in Canada for a long time. Many have already been here for a long time. Given the levels plan, it's likely that they will have to continue working on their business on a temporary work permit, especially if they're essential. So they've given some flexibility where it is for 3 years. You're not having to extend each time. And then you also have the ability to work outside of your SUV business. Now, what they didn't do is provide really good guidelines on what an applicant should think about when making that decision. What we've counseled our clients is do not get into a process where you simply take the right of an open work permit and engage fully in the labor market and work for IBM or your dream job, and you're working 40 hours and occasionally on the weekend you put your eyes on the startup. That wasn't the intention. The intention was that you can achieve your means of being able to take care of yourself and your family and get some extra cash from your side business, perhaps, to invest in your business. And you will be still accountable. There still are employer inspections for SUV applicants where you have to demonstrate your activities. And even with the additional document requests, they're often asking about your progress. Have you signed contracts? Do you have revenue? Are you marketing? Do you have a website? Very active sort of participation. So we've come up with what we call a 70-30 or an 80-20 rule to start, which is if you need some additional cash, many startups, people wear multiple hats, do it, but do not take your eyes off your startup visa. That's your primary purpose. There is a regulation on artificial transactions, and you could be set up for failure if you jump into that open work permit. That could be evidence that, in fact, your primary focus when you were in Canada was to work for your dream job. You're not really keen on the SUV program. It was more of a way to get a visa or get an immigrant visa. So be careful about it, but I think it does give a level of fairness. We've met many applicants with the pricing in Canada, housing and just cost of living, where when you're starting a new business, very difficult to be able to meet all those requirements. And in fact, on some work permit applications for extensions, the issue was there wasn't enough settlement funds because they were not generating enough income. So this allows individuals to get a little bit more traction. What we've also thought about in our offices, in some cases, we've met applicants who have come to us, and there's some fairly fundamental issues in their previous SUV application. And so where you can get a 3-year open work permit, it also gives you flexibility to try to fix and amend the issues in your SUV, but you also have 3 years to try to find out if there might be other options for you in Canada. So I think it's a huge benefit to get a 3-year open work permit, no matter what happens with the SUV program. Once you have a 3-year open work permit in your hand, it's valid until the expiry, as long as you remain admissible. So I think it's a huge benefit, but something that you should use very wisely and think about your strategy.
Naman, I actually met with Minister Fraser at the point where he was making that announcement. We even taped it. It's on my YouTube channel where he is very happy. We're now allowing for this 3-year open work permit, even though he said on stage at Collision that they are now doing it. A year and a half later, finally, it gets implemented. But I challenged him. So we're talking face to face and said, well, that's a horrible decision. I actually tell him I was not in favor for it because you're going to bring in a team of 5 and then head of IT goes and does work for IBM. Chances of him coming back to the startup are minimal. And so how do you feel about that? And his answer was, well, at least we brought bright individuals to Canada. So of course, that's a politically correct answer, but I think that was detrimental to the StartupVisa. I was happy for a first year and a half that they didn't put that into action. He also did follow on and say that, yes, startups do not make money their first year. We don't have the anticipation that they're going to be profitable even in the second year. So people have to self-sustain, to what you said. They have to be able to go get a well-paying job or a paying job while they are growing their startup so they have funds to live on, which again is in alignment with what you said. So, but if you do, or anyone on this call, and there's a lot of people here, if you do want to see the actual announcement that really was a year and a half, way too early, it is on the YouTube channel of ours. So over to you.
Yeah, but and I think the other comment when you're talking about, the actual process of considering a work permit, getting a work permit, there has been a little bit of misunderstanding. A lot of people see 3-year open work permit and think it's like an automatic right. You just apply for it, you get a 3-year open work permit. All the other criteria still exist, and in fact are looked at very carefully. So of course, you have to have proof that you and your group have filed your PR applications, but you still have to demonstrate your significant economic benefit. Are you creating jobs? Is the product or the service innovative? What's the impact if you're going to be based in a region that needs job stimulation? You need to articulate that. If you have a staffing plan or a vision in terms of how you're going to grow, you should articulate that. Of course, your letter of support. And think carefully too. We've had a lot of cases from parts of the world, Southeast Asia, Pakistan, the Middle East, parts of Africa, where there's also massive currency fluctuations. So at the time of filing the application, the individual had sufficient resources to meet the cutoff requirements. But by the time the officer opened the application, in some cases, the currency had depreciated by 50%. So all of those factors are still looked at. And in fact, I would say the certainty of knowing how they're going to adjudicate your work permits very unclear internationally at all the visa posts. Some have just an unfortunate reputation of refusing. And I think there was some information that was released by one of my colleagues where the refusal rate, where they simply are refusing, saying you applied in the wrong category, when in fact they applied in the proper category, is quite high. So in what we've learned through experience is that our work permit application is actually a piece of guidance and education for the officer, explaining very carefully what the policy is and what they can look at, what they cannot look at. The federal court has a case on this. There's a lot of times where they refuse. Actually, it's kind of ironic. They refuse, saying, we don't believe you're going to come back to Canada. And it's ironic because the SUV is a PR program. It's for permanent residents. The idea is people are going to come in. So dual intent allows them to get a work permit, but they should be looking to stay because the purpose is that they're going to run a business and get an immigrant visa and stay. So a lot of this needs to be explained in the work permit application. But overall, this is a positive change given the current climate that we're in.
Now, I have seen in the past, and you were working not with an incubator where I participate, so I'll put that asterisk there, but you have worked on over 100 refusal cases for work permits because they were filed under their own category, and it was your job to re-educate whoever was filing, plus IRCC, to make sure that no, not C10, C11. Can you speak to that?
Yeah, so it's actually, we get clients that are really concerned when they get the refusal, and we're pretty calm about it now because we've seen it. So when it comes to us, we have an approach. So the first thing is, in some instances, we actually seek a reconsideration and we go right back to the officer with the additional information. Where we're a little bit handcuffed is if the first application that was presented was deficient, where we didn't address the requirements of the work permit, in which case then we have to file a new application. But yes, what we've done, which is a little unique, is in our applications, we do have a fair amount of guidance and case law right on point. And then as necessary, we can escalate internally and, with the designated entities assistance, we can get some eyes on that application, particularly when we all agree that it's an error. Even inside of Canada, where we've seen that, we've been fortunate that we've been able to get those fixed within 2 weeks if everything lines up correctly. So yeah, we have an emergency triage team, and we sort of know the drill because unfortunately we've seen it so often, and we have raised this issue with Ottawa that there really should be, in our mind, like a dedicated team that looks at these particular types of work permits, because we do appreciate for an officer that spends, I think the statistics are they spend about 6 to 7 minutes, right, making the decision. If they haven't seen it before, it's easy to be a little unclear. And I guess if you've got 30 other cases, you move fast and you can make mistakes. But we'll keep sort of advocating for that. But in the interim, yeah, there's an approach that you have to take, and it can be fixed. So
And
we
again,
have
this is a moving target. In the past, every application was pretty much treated the same. Now there's priority streams. Those that were not in priority streams, they can still make themselves a priority stream with some extra investment. In the past, most designated organizations were, I would say, indifferent whether there was 1, 2, 3, 4, or 5 partners. Now, most designated organizations prefer stronger, bigger teams because they just have a few spots of what to approve. So to put both of us on the line here, crystal ball in hand, what are our recommendations for 2025 when it comes to StartupVisa? I'll start off with, considering I'm on the side of business, more robust business plans, more exorbitant to-do lists, what you're going to do when you hit the ground running here. What is going to be your hiring plan? What is going to be intellectual property plan? What are the activities for every team member, as well as those people that you are going to be hiring? So truly sticking to the economic impact. Look for those innovative ideas to make sure that when the officer is reading the business plan, he was like, hey, I would want to invest into that business, to be that strong about it. Full disclosure on everything. So this way, none of the members will go back and say, hey, you forgot to say that you were denied for travel, or you were denied entry, or you overstayed. So make sure there is absolutely full disclosure, both in a business plan and immigration filing as well. Also, have a close relationship to people like us in the designated organization field, because they are asking, are you still talking to us? Are you still working with your mentors? Are you still attending seminars and meetings? What is your activity level? So IRCC goes back and asks both sides if communication is constant, continuing, and what are the updates. So my crystal ball on this, when I started this, let's talk about a decade ago, an applicant could have passed with a business teaser, summary, two-pager, plus a letter of support. Today, you have to have a robust business planning kit, which is close to 1,000 pages between all the different documents. So make sure that just like if you were to go to a bank and ask for a loan, just like if you were going to a venture capitalist or an angel investor, having entire data room with all of the assets of that business, with all of the agreements, with all of the clients, with all of the projections, all of the documentation. Treat government when it comes to StartupVisa as a venture capitalist, where they are going to ask you about the entire business structure, full projections for the next 3 to 5 years, what you're going to do. So make sure you have amazing documentation to submit and ready to go. Naman, Howard, what is your crystal ball for 2025 looking like?
Howard, do you
Well,
want to?
I can go back and just comment on some of the comments. Strategically, number one, everyone who has a work permit, a closed work permit, should get an open work permit as soon as possible. Everyone. And the reason for that is simply strategic. If a application is refused, there is no prospect that that applicant will get an extension of a current work permit. So as soon as that refusal is entered into the system, that creates a very precarious situation for an applicant in the middle of developing their business. If they can move to an open work permit for 3 years now, they have runway or time. Even if their permanent resident application is determined negatively, that does not directly impact the existing work permit that's issued. It does not invalidate it. The regulations do not do that. And so, number one, move to open work permit as quickly as possible. Number two, make sure that the 70-30, 80-20 rule is implemented. Applicants are so concerned about getting alternate employment and obtaining, money, a salary, that they start ignoring their business proposal. That could be detrimental when the officer asks for an accounting of the business development. I can't think of anything worse than having to reply, we haven't really done very much because we've been working full-time in another job. That would be detrimental to the application. 70-20, 70-30, or 80-20, some kind of process you put in place, or some sort of defense you put in place to show that you've been developing your business while you've been working. So those, in my mind, are the two key go forwards for 2025. And we use something called an activity tracker. An activity tracker requires our clients to go online and insert every single step they've taken while in Canada: incorporation, meeting with a lawyer, meeting with a customer, signing a contract, discussions at an educational institution about research, depending on the area that they're in. That activity tracker tracks it all. At the time that the officer makes further inquiry as to the efforts in establishing the business, because that officer is concerned about the bona fide of the business. Were they really coming to Canada to establish the business or just get an immigrant visa? That's the test. We take out the activity tracker and show streams of pages of activities which were undertaken to perfect the business, to get the business going. And this is probably something, Slava, you can even comment on. There's no requirement that the business be successful in the first year or two or three. There's no requirement that the business be profitable. There's always concern amongst our clients. We don't have enough sales yet. That the objective of the program was not to turn you profitable before you got your immigrant visa. In fact, there's no relationship between those two concepts. As long as you bona fide are attempting to get your application, your business going in accordance with your business report and your application, the how strong your business is does not determine whether you're successful. On the other hand, no efforts to get your business growing is probably fatal.
You are correct in the sense that what we are getting back from IRCC, they're asking, what is your activity? How many sales calls have you made? How many sales emails? What are the interactions? Potentially, we've seen at least once or twice who were the people that you were contacting. Is there any memorandums of understandings or letters of intent that you're signing? So when they are truly questioning the startup, they are looking for the deeper information of the activity. So just like within your firm, we are asking our clients, we're broadcasting, we have a webinar that is ongoing for them. What is the minimum required activity? We never say maximum or what you should be doing. We are saying what is that minimum that you should be doing, and our minimum should be, I would say, the median of what the industry is asking for. So we are talking to them about attend trade shows, additional courses, meet with clients, continue on your research and development, do sales activities. So there's a list of activities that we are asking clients to do to make sure when that question comes, if it comes, it doesn't go to everyone, but if it comes from IRCC and they're sending it, they're actually asking, outline your activity, provide us a report. So we give our clients templates as well of what that report should be looking like. And knock on wood, so far, all is good for our clients when we're doing that.
I'll jump in. I'll give you a couple points, right? That I think it's a big SUV ecosystem out there. The one recommendation I make is if you're firstly self-represented and you filed your application, or if you filed your application and you haven't had a lot of guidance from your representative on the expectations of the program, get a health check. I'm shocked when we meet with clients who believe the program was something other than it is. They believe that getting that the letter of support and having the language test and completing the forms, that they did their job and they will get their PR. They've been shocked to understand how much effort between that point and when you get your PR is required, to the point where it was like the first time they understood the program properly. In terms of documentation as well, some of the applications we've seen are very light. They really haven't explained the business properly. And when we look at what was in the application compared to what's actually happening, it's night and day. And so there has to be a gap fixer there right away. So I would say these certificates are precious now. There are 10 of them. Ironically, I think IRCC thought they're going to delay, limit the processing, but it's also resulted in really high pricing because it's a precious opportunity to get a certificate. And so if you're one of those people with the certificate, you have to protect it, right? So treat it properly and make sure you have someone that's working with you regularly. And there's a lot of twists and turns in this program. So you have to be engaging regularly with your team, whoever is supporting you on this. And the second, my hope in 2025 for the program is that we find the next right party to fill the gap. We don't have NACO. There was quite a bit of concerns that NACO had other priorities. It wasn't the SUV program, but there needs to be a interaction between designated entities and clarity. so that it's well understood what is required, what is the standard of due diligence. We don't have peer review anymore, and that had its own flaws. I mean, it wasn't really independent arm's length. There were conflicts in how that was structured, but there isn't a lot of checks and balances to keep everyone working in a consistent way that you would expect in a program to operate well. And so we hope whether IRCC does that directly themselves or if they go to tender, they find a third party that's very much committed to doing this right. I can tell you, we provide a lot of support and advice to designated entities because they're concerned as to whether or not they're meeting the standard because there hasn't really been a standard set.
No, the
So
carrying capacity could have
that's
been business teaser. So that was
yeah,
not standard.
right. And so I think that needs to get into place. And I think then there's a measuring stick and there could be accountability. And I think if you're a designated entity, you should also be getting guidance to understand like what is the actual standard in the industry and how do you measure up? Because the other perspective I have is in the next year, there are only 10 certificates per designated entity. IRCC can very much look and understand who you in fact supported and what have they been doing and infer the quality of your selection process. And I think this is a time of reflection in this momentary cap. The cap is for a couple of years. They haven't suggested that this is the way it's going. In fact, and Slava, you would have seen that too. The entities and third parties and law firms have been canvassed quite regularly about what we think about the cap and what the future of the program is. So I think as an industry, we really need to make sure that each one of these processes has built-in integrity to preserve the program. We've got about 5 or 6, and I'm sure, Slava, you would see some success stories where companies have come in, they've done great and received massive amounts of funding from big players to amplify from Canada. It's exactly what the program was dedicated and designed to do, but we need those checks and balances.
Yeah, I absolutely agree with you. And considering we have about 5 minutes until our 10 o'clock mark for the continuous news, I would not be reading Government of Canada website because it continuously changes. I would continue going to webinars just like this. Of course, follow Naman, follow Howard on LinkedIn, on other social media channels. We do advertisement on StartupVisa.com, which is a place where Startup Visa experts are hanging out. And if someone wants to go and speak to Howard, Naman, their email address is right here on the bottom. Their phone number is on the bottom as well. So make sure that you get in touch and find out more. So to close off my remarks, I'll ask for the same from Naman and Howard as well. My remarks are unexpected. I did not think we're going to go from, hey, you can issue as many letters of support that you want to, just you can per designated organization issue just 10. I did not think that IRCC is going to say from you can change that letter of support as many times as you want and pivot it until PR is filed to, hey, no one is allowed after kind of PR is filed to be changing anything in that certificate, even though businesses pivot, businesses change. I did not expect NACO to be out of picture. I did not expect that we are going to lose the process of which kept designated organizations in line, that we are going to miss out on these, let's call it secondary interviews or called peer reviews. And I have been to many of those, truly defending the case for its merits, convincing other designated organizations or other members of NACO that this is a good venture that should be brought to Canada. So expect the unexpected. Whatever has been working in the last 13 years in a program, there is going to be another change, and I'm sure of it, in 2025. Naman and Howard, over to you.
Yes,
I'll
look,
go ahead, Howard.
I wanted to make one last comment. The environment has changed, Slava. You're quite right. The PR levels, permanent resident levels, have been dropped over 100,000 in the plan. The number of work permits that will be issued will be significantly decreased. There's a rising concern about fraud and misrepresentation in applications as early as today. discussion of the LMIA program and possibly changes to that to meet the fraud concerns. It's absolutely critical that you get the applications right, that you update them properly, and that you're watching every step of the interaction with IRCC. It doesn't take a lot these days to have an issue, to have a problem.
I'll incorporate a 30-second comment that ties both comments. I think, yes, expect the unexpected. And if you're interested in business immigration, Startup Visa is one of the last, programs standing. Very difficult. PNP is very challenging. There's no self-employed. So if you're interested, get the right people, get the right advice, and file when you get your certificate. Don't hesitate. File quickly, do it properly, because we don't know what tomorrow is going to bring. So try to lock yourself in if you're really keen, because it's a tough environment for business immigration in Canada right now.
Well, thank you, everyone. Thank you for our speakers, Howard and Aman. We have been recording this. I will put this on the YouTube channel for those of you that have missed out something or had to go get a tea, considering it is early in the morning. We are planning to do more of these as the news are coming out. So please follow us on social media. Most of you have found out about this through social media. So continue following us and subscribe to our channels. Thank you, everyone.
Thank you.
Have a great morning for those of you that are here in Toronto, and for those of you that are overseas, have a great evening. Bye, everyone.
Thanks, Alex.